Was just asking you about Vanetta Guffey mentioning a homicide, correct?
Yes, that's correct.
And she's making a point that you never mentioned homicide.
That's correct.
Okay. Now, we're aware that there were many street rumors going around at that time.
Yes, from my review of, for example, Instagram at around that time, certainly there were many. I don't think it's a mystery that there were a lot of rumors going around about concerning the murder at that time.
And so there could have been many ways that Vanetta Guffey could associate Shannon Stillwell with a quote homicide.
Yes, it wasn't a top secret government secret, so to speak.
Oh, no. Mr. Sprinkle, how would you suggest we get inside Miss Guffey's head and figure out how she knew about homicide?
Well, clearly we wouldn't be able to do something like that. The technology doesn't allow for it.
Well, what would we do?
Cause for speculation. The question, form the question.
Can we? Well, when you want to know what's going on in someone's head, is there a way that you could inquire?
Well, yes, you could ask them, but of course, Miss Guffey, we can't ask now because she is deceased.
Oh, so what we're talking about, we can't inquire about what was going on in Miss Guffey's source of knowledge because she's unavailable now.
She is unavailable now, and based on my interaction with her, I don't believe she was interested in answering any more of my questions at any rate. But now it's, of course, an impossibility because she's dead.
And she's unavailable to the defense as well.
I'm sorry?
She's unavailable to the defense as well.
She's unavailable to everyone, assuming that my information is correct, that she is, in fact, deceased. That's what I was told yesterday.
Okay, and she passed during the pendency. I know you don't know the exact date, and that will be tendered into evidence, but she passed during the pendency of this case, is your understanding?
If she died between the date that I interviewed her and today, then that would be during the pendency of the case.
Okay. One more thing. You asked if anyone instructed you not to indict the case to gain a tactical advantage, correct?
That's right. Yeah, that was never ever part of our conversation.
But again, you're not the one who decides when to indict the case, correct?
No, I'm not.
Okay. All right. Thank you.
All right. Mr. Jimenez? Ross?
Your Honor, as the person who's going to make the legal argument, may I make a short argument to the court?
Sure.
This is the defendant Stillwell's motion for constitutional speedy. That is his personal right. Now, the evidence that will be introduced at trial will be introduced against all of them unless there's limiting instruction because of the RICO count. However, the issue on whether one individual's constitutional speedy rights were violated is specific to him and does not apply to anyone else. And so there's no motion currently before which any cross-examination by any other particular defendant's attorney would be at all relevant, and there'd be basically this is testimony that is relevant to his and his motion only, Mr. Stillwell's. And so we would object to having anybody else cross-examine Mr. Sprinkle only because it is not relevant to the issue that is before the court.
Okay. All right. Thank you, sir. Go ahead.
Thank you, Your Honor. Good afternoon, Mr. Sprinkle. How are you?
Very well. How are you?
Sudi Chakaman on behalf of Mr. Dorsey. I just want to go through this as quickly as possible. I know everybody has things to do. Let's focus on the timeline. I'm interested in the timeline. When did the murder happen?
January 10th, 2015.
All right. So in 2015, that's when the investigation happens. And then when is Stillwell arrested?
October 27th, 2015, if I remember correctly. It was definitely towards the end of October 2015.
When did you get a chance to talk to Mr. Wright?
That would have been January of 2016. Matter of fact, I believe I can actually give you them refreshing my recollection. It'd be January 12th, 2016.
And Mr. Wright had been arrested and taken to the Atlanta City Jail. Is that right?
He'd been sitting in the Atlanta City Jail since October of 2015. That's correct.
Now, he was in the city jail on misdemeanor or felony charges?
I believe it was felony charges, a felony probation violation warrant, perhaps. He also had that gun. Maybe he was charged with that, but his charges were it was within the jurisdiction of the Superior Court.
Okay. And do you remember, is it accurate to say that when he was arrested, he actually did not see a judge within 72 hours? Do you remember that?
Objection, Your Honor.
Now we're going to.
Okay. I'll move on. You testified during direct that you had a chance to listen to a call by Mr. Wright. Is that right?
I did. Yeah, that was the jail call that he placed to his friend shortly after his arrest. Jaquise Smalls is actually the friend's name. I didn't remember it on during Mr. Shart's cross-examination, but that's who it was.
And after you heard that call, did you know that it was him? Did you recognize his voice when you heard that call?
Mr. Wright?
Yes.
Well, at that point, I had interviewed him, so I was familiar with his voice. This is going back a little bit. I'm going to go ahead and say I must have recognized his voice.
Is it fair to say you recognize his voice because you had interviewed him in person before?
Yes.
I'm going to object as to the relevance.
Now, what's the relevance there, sir?
We're trying to see if that is.
Does it have anything to do with your client, though? Because remember, even though statements, I'll give you wide latitude if you're trying to cross as to statements that might be attributable or relevant to your client.
Yes, Your Honor.
Let's kind of focus and narrow it.
I'll move along.
Right.
Thank you, Your Honor. After you spoke with him, then you wanted to verify that whatever he was saying was true. Is that right?
Well, if we're speaking about Mr. Wright, I was verifying that what he had said previously to the police was actually not true. And I was trying to confirm that this person had essentially made everything up.
Okay. And you had access to the video.
I did.
And then when you watch the video, whatever this person claims that happened, whatever Mr. Wright claims that he saw, it would have been impossible because he's not seen on the video. Is that right?
That's right. He said he was at the bus stop. I believe he said he was standing there listening to an iPod or something to that effect. And he was very specific. But then when I showed him the video, I said, there's nobody standing there, and he didn't have a satisfactory explanation.
Once more, Mr. Dorsey is not charged.
I sustain the objection.
This happened, all of this interaction happened around 2016, correct?
Yes,
You testified a little bit about how there's been changes in leadership at the office. Is that right?
that's correct.
There's been at least 3 other people that were heads of the gang unit since this happened. Is that right?
That sounds about right. Yeah, it was Adrian Love, Kara Convery, and then Chris Sperry is the current head of the gang unit. Gabe Banks was the head of the gang unit when all this happened back in 2015.
Ultimately, can you tell us with some degree of certainty at what time did you determine you had enough evidence to go forward on this count and include it on the RICO count for Mr. Stillwell as well as his co-defendants?
What time did I independently figure that out?
Yes, what time did you?
Well, I think that around the end of 2018, we could have pursued an indictment.
Okay.
Not against Antonio Sledge, Kenneth Copeland, Demikian Garlington, but against the people that are currently charged with the murder. But I know that a lot was done after that, particularly in 2021. There was a wiretap, et cetera. And I also know that there's a difference between probable cause and beyond a reasonable doubt. So probable cause, of course, is the standard that we would need to secure an indictment. So if I'm being honest, which I must be as I'm on the stand, I would say by November of 2018, we had enough evidence to pursue a murder indictment. For probable cause, we had probable cause, I should say, not necessarily that we had enough to get a conviction.
Okay.
We could have obtained an indictment.
No, let some other people. Okay, at this point. Okay. All right. Anybody else?
Thank you, Your Honor.
Okay. Just wait, Mr. Sharp. Okay. Anybody else? Going once, going wait, Mr. Sharp. How about it?
Mr. Sprinkle, when you said November 2018, you were speaking about all 5 charged individuals, correct?
Yes, we would have had. I think we would have had probable cause in November of 2018.
And you would agree that probable cause against Mr. Stillwell individually existed well before that date. We could, okay, so to your question, January 2016, what did we have? We had Quindarius Zachary's third-party confession against him. That's really about all we had in January 2016, and he was a co-conspirator, fellow gang member. I would be, I don't know what the grand jury would have done if we had presented that. If we had presented that evidence to them, certainly there was some evidence that third-party confession. We also had Kenneth Copeland's statement to Investigator Gaither and Dennis. Obtained this evidence from Termon Stillwell.
That would have been after January 2016, but yes, I did.
But that would have been before November. When
That was March of 2016, the interview with Teron Stillwell.
2020 person claiming agree that you could have taken his degree.
Yes.
Thank you.
All right, anything further, madam?
No, Your Honor, thank you.
All right. I
And
mean, Mr. Sprinkle be permanently temporarily excused at this point in time for purposes of this motion.
yes, Judge, thank you
All
very
right, Mr. Sprinkle, sir, I'm going to go ahead and excuse you as a witness at this point in time. Don't discuss your testimony. Anybody should be changed in this case, okay?
Yes, Your Honor.
All right, thank you, sir. All right, argument.
Your Honor, I just have a couple of documents to admit to evidence.
Okay, all right.
Um,
Let me do this correctly. State have anything further in regards to evidence
much.
on this particular motion? The
No,
mo-
Your Honor, thank you.
Okay, motion is dismissed. All right, okay.
Your Honor, I'm sure you can say, Defense Exhibit 1 is a certified death certificate of Benedict Guffey, who passed on 7/14/2021.
Okay.
I'd ask that you-
Any objections to D1?
No, Your Honor.
All right, D1's admitted.
I have D2, which I guess I could ask that you take judicial notice of, but I've marked it as D2. It's a motion for constitutional speedy trial filed on behalf of Mr. Shannon Jackson, aka Shannon Stillwell, under the unindicted case number for this case, 15 CP 155953, dated July 2nd, 2019. And it is in Odyssey.
All right.
Um,
Any objection to the court taking judicial notice of that?
No, Your Honor, I was going to bring
that
this
in-
to the court's attention.
Okay, all right.
and
Then D2's admitted.
I'll also,
Well, I will consider it for purposes of the motion. Anything else?
yes, Your Honor, I would ask that you just, as you did with the state,
I'm sorry, one more time.
I'm sorry.
You gotta speak in the microphone so
Yes.
everybody can hear you.
Yes. I would ask that you take into judicial notice, as you did for the state, to the fact that in this case, 2 additional constitutional speedies have been filed for Mr. Stillwell, one on May 9th of 2022 under this indictment number, and one on August 5th, 2022 on September 30th, 2022, the constitutional speedy was filed, excuse me for that, and then an amended constitutional speedy was filed as well, Your Honor.
I'll take judicial notice of those two.
And I would also ask Your Honor to take judicial notice of the standing order from Judge Brasher and also the Supreme Court of Georgia that no statutory speedies have any effect until January 1st of 2023.
Okay, do you have copies of those that you'd like to add for purposes of record?
I can supplement the record if Your Honor will allow me. I don't have those printed out at this exact moment.
All right, I'll take judicial notice of the standing order issued by the former Chief Judge Christopher S. Brasher, as well as the standing order issued by our Supreme Court of Georgia in regards to speedy trial demands and totaling thereof. Okay, anything else?
As far as evidence, no.
Okay, all right, argument?
I do have argument.
Go ahead.
If I'm the movement. I'm the movement.
Yes, you are.
I would waive my opening if I'm allowed to give a closing after the statement.
Well, it doesn't kind of work that way on this particular issue.
Okay.
You need to go ahead and walk through those particular factors that that in terms of okay, so we're dealing with the bar. I mean, just to give you kind of like a framework, and you certainly are very experienced as to this. 1 second. Young man in the back over there in the tie, could you please get rid of your gum? No, you're turning around. Yeah, get rid of your gum. Don't swallow it and bring personal injury to yourself, okay? And don't stick it underneath my seats, all right? Mr. Harvey, how come you didn't tell him that that was one of my verboten rules?
I was watching the.
Obviously, okay, all right. So under
Chewing tobacco.
so that's even worse. Under Barker versus Wingo 407 US 415, and in the dogged, there are four factors that I have to consider, okay, in deciding this. Factor number one is the length of the delay. 2, the reasons for it. 3, defendant's assertion of his right to a speedy trial. And 4, the prejudice to the defendant. And of course, I have to go ahead and look at that. And the threshold, of course, issue is from a constitutional speedy trial demand is the interval from the arrest, indictment, or other formal accusation to trial. And we haven't gotten to trial, but we are going to trial on the 9th of January of 2023, is considered to be presumptively prejudicial. So go ahead and start out with that. That's your roadmap. The state has responded. I'll let them go ahead and, of course, go ahead and make their argument. But go ahead and start off with the delay.
Would it be helpful to Your Honor, and I will follow your instructions, would it be helpful to provide a brief timeline of the key dates? Or is that clear to the court?
It's clear to me. I mean, to the extent that you need to be able to show me. So, I mean, I think that if you need to establish when your client was arrested, when he was indicted, any other relevant dates for the purposes of establishing what the court and my determination of delay, what that delay is, and who that delay is attributable to, because that's, of course, I have to weigh that. And of course, factor number 2 requires me to look at, I think your client, let me complete my thought to begin with. I apologize, sir. Factor number 2 is the reasons for it. 3, the defendant's assertion of his right. 4, prejudice to the defendant. So it looks like on or about the 27th of October, 2015, he got arrested for the murder of Donovan Thomas. And then apparently there was you can take it from there, okay, and then go ahead and give me your resuscitation as to how you believe that that you were that this delay, because that's the first thing I have to kind of consider.
Right. I would agree that October 27, 2015 starts the clock. Of course, it's the earliest of arrest or indictment.
And I need to decide whether or not it's presumptively prejudicial.
Yes.
So, and if I do, then if I don't, it fails. If I do, then I continue on from there.
Well, we are at 7 years and 2 months since the date of arrest. So the presumptively prejudicial threshold is often considered 1 year. So I believe that we are well past the presumptive prejudicial aspect of this, and I believe the state concedes that. And
no statute of limitations for homicide, though, right? Or alleged homicide, right?
Correct, but I would say that that's a completely different issue altogether. I mean, it is true that there's no statute of limitations on homicide, but and so if they had never arrested Shannon Stillwell on October 27th, 2015, I would have none of these arguments.
Okay,
but they started the clock with the arrest.
I think the state concedes that a delay approaching 1 year generally is deemed to be presumptively prejudicial.
Right.
So they've discussed with through Mr. Sprinkle that they had some investigatory issues that were going on at that point in time. They might have had enough to seek an indictment, but not a conviction. And, you know, in terms of the way that their case developed and the interrelated nature of the homicide and potentially some gang affiliation. So they've testified about that issue as to why it took so long. Because you're asserting, well, they did it for tactical advantage, and as a result, Miss Vanetta Guffey's dead. You can't call her as part of your witness. That's prejudicial to you. Is that right?
It's slightly more nuanced than that. I am not asserting Miss Guffey. In all candor to the court, you'll see it in the death certificate. She died of a brain aneurysm, and it was an unexpected death. I am not asserting that the state secretly knew that Miss Guffey was in bad health.
No, and I'm not saying that, but generally, whenever you have a witness on availability issue, then you got to be able to establish that it would have made a difference anyways. What she would have tested, what you would have. But we don't. The challenge we have with that is indicated by the state, is that we don't know necessarily what she would have testified to, what the weight and value of her testimony would have been, if it was reliable or unreliable, whether or not they would have called her as a witness, whether or not that would have made a difference in your case. So to the extent that if you can address Ms. Guffey and tie that to something that you think that's prejudicial to your client,
I will. Would you like me to go straight to the fourth prong, or because they're all interrelated?
I know they're related, okay, but yeah. So is there anything else the length of delay you want to call it?
Yeah. Well, there's a few things I'd like.
Because then you can move on to cause of the delay.
Okay.
Okay.
All right. I would like to point out that Mr. Sprinkle, under oath, honestly testified that he does not control when to indict cases, but in his estimation and experience, they had enough to take Mr. Stillwell's case, Mr. Shannon Stillwell's case, to the grand jury in March of 2016. I am not concerned with any co-defendants. I am not concerned with the status of the case of anyone on this RICO count for the purpose of this argument.
Okay, but
They had
the state, and I'm hijacking because I want to have a conversation with you about it, is that they being the state has indicated to you and that they certainly probable cause, to get an indictment, but not beyond a reasonable doubt to convict. So they've told you the reason why they waited. You don't accept that particular explanation from them?
I don't think Mr. Sprinkle ever told us why he waited on Mr. Stillwell, because he doesn't know, because he wasn't the one that made that decision.
But he did testify that he said, in all honesty, because I'm an officer of the court, I'm required to be honest. We had enough for a probable cause for an indictment, not enough for to prove beyond a reasonable doubt, which is trial standard. So that's what I took his testimony to believe in terms of, sure, he could have sought an indictment in 18, but that's not, but ethically as a prosecutor, you don't want to necessarily indict and then search for evidence. That's not how it works. You have to have, certainly, you can certainly develop other evidence and whatever, but he's telling you that from the strength of the case that they had in 18, it wasn't enough.
Well, I don't think he said that about Mr.
I know he didn't say that, but that's what the court's going to extrapolate from his testimony.
Well, Your Honor, I'll back up a little bit. And the purpose of constitutional speedy is we're talking about they need time to develop. The purpose of constitutional speedy trials is they're supposed to develop before arresting someone in taking
somebody.
Yeah, taking their liberty away. They're supposed to have a case. And the idea that they went and locked Mr. Stillwell up and now we're saying, they didn't have enough to proceed on him, yet at the same time, no one from the DA's office said, hey, we don't have enough to proceed on him, so let's drop these charges.
But remember what Mr. Sprinkle said. At some point in time therein, it developed that this homicide may be interrelated with a RICO case. And that's why they decided to go ahead and further develop in that particular issue. So I'm going to weigh the delay factor slightly against the state. Okay. Let's move on to number 2, the cause of the delay.
Your Honor, I would just like to say that I would just like to stress it was 7 years and 2 months, and that they did not seek an indictment until 2020.
And you know what? They are. You know, I think that that factor is going to weigh against the state, but it's only going to weigh against it slightly or benign. Okay.
And I'll also point out, Your Honor, that the case law and just regarding delay, just for the record, Your Honor, the presumption of pretrial the prejudice from pretrial delay intensifies and compounds over time. And
yeah,
there are cases in Georgia where delays less than this. State v. Sutton, 7 years delay was egregious according to the state, and it removed the need to show particularized prejudice, which we have here. But I would just like to stress to the court that the delay is not, before we move on to the next thing, and I am going to move on, that the delay is not an isolated factor, but it also affects the ability to show the other factors.
I agree. I agree with you.
Okay, and that's,
yeah, I agree with you because it does affect it bleeds into the second factor, and it bleeds into the third factor. So I understand, and don't disagree with you in the least. Okay,
and so I'll move on to cause, and I think this is important because, Your Honor.
Okay, so I got a question for you.
Yes.
Do you think the state deliberately tried to delay your case?
I think they made a decision. They made a tactical decision, and Your Honor, in just asking
do you think that they deliberately delayed your case in order to hamper your defense? Because that's really the issue. Did they delay you to hamper your defense?
Well, Your Honor, I'm going to cite the Hayes v. State.
Now, answer my question.
Well,
answer my question.
It's not,
did they delay your case in order to hamper it?
There's 3 levels. There's not just 2.
Well, answer my question. Did they delay your case in order to hamper it?
I don't believe that they deliberately acted in bad faith, but I do believe that there's a middle ground under Hayes v. State, 298 Georgia.
Okay, well, it's not negligence. They're not saying, well, hey, we had an overcrowded docket. He slipped through the cracks or anything such as that that's argued in many of these cases. So they've told you, you might not like it, but they've told you why it is that you they had a protracted investigatory period, let's just say, on your case.
I would agree that there was a protracted investigatory period. I don't necessarily agree that all of that involved Shannon Stillwell. I believe that they had that case wrapped up in 2016.
Okay, so if I believe the state, which from their testimony, then that's certainly a reason that I could do it and it would justify that delay.
Well, I don't believe so. And
why not?
I'm going to explain why. Well, first of all, we haven't heard.
Well, under Barker versus Wingo, that is what I'm supposed to look at.
I agree, but Barker v. Wingo has been
something. I mean, you have to show a deliberate attempt.
I don't agree.
To go ahead and
Your Honor, I don't
do that.
Respectfully, I do not agree that I have to show a deliberate attempt. First of all, I don't believe I have to do so with such an extreme delay. But secondly, Your Honor, there is a middle ground.
Okay, let me rephrase. They have told you why it is it took them a protracted period of time in this particular case. They've told you through Mr. Sprinkle, more than the proffer. He's put his hand up and he said, listen, we had this homicide. We started to develop other information. There might have been retaliatory shootings in regards to this homicide. There might have been gang affiliation or gang activity related to that. And they didn't, and the interrelationship with those 2 aspects, as testified by Mr. Sprinkle, that would be a reason for them to justify the delay.
I respectfully, Your Honor, disagree.
Okay, we're going to have to disagree on that.
Well, and I'm going to say why, because it was a decision It was a decision they made that they wanted to put the 2015 case.
But what was
that
the decision based on, sir?
Well, I will respond to that. First of all, Mr. Sprinkle made it clear he wasn't the one that made the decision, so we don't really know what the decision was based on. But it's clear to me.
Well, well, listen. From the testimony that's been given, this is the case that the state developed at that point in time. And whether or not they decided to pull the trigger and indict the case, which they told you they could have done it in 18, but they only have probable cause. They didn't have trial beyond a reasonable doubt, which is an ethical issue. Remember, Mr. Sprinkle says, I can't just indict something. I mean, that's why we get in this whole discussion all the time about ethical prosecution. Mr. Sprinkle had enough sense to tell you, hey, at that point in time, we're not indicting it because we don't have enough to be beyond a reasonable doubt. So
we're not indicting it. We just arrested him and had him in jail. And I mean, they are the ones that triggered it with the arrest. And the law requires them to pursue the charges once they make.
Do you think this is a complex case or a simple case?
I think it's a very simple case that they have chosen to make complex.
It's pretty complex.
Well,
you got 28 folks.
That's exactly my point.
You got a 65-page indictment. You have over, I think it is, how many counts do you have, Ms. Love, now?
65.
65 counts.
And that's exactly my point.
So I mean, it's not simple. So if looking at Howard versus State, 307 Georgia Appeal 822, 2011, you got an allegation by the state of continuing criminal enterprise. You got the RICO issues. You got you got a homicide, and you got a lot of acts that the state has to investigate. There's a lot of work with this case. So I'm gonna say to you that that this particular cause of the delay, I don't believe that the court is of the opinion, based upon what I've heard in terms of testimony, that the state intentionally delayed this case to hamper your defense.
But, Your Honor, I just want to make clear for the record, my point is not that they intentionally did it to hamper my defense. They made a deliberate tactical decision on State v. Shirley, 311 Georgia Appeals 141 is a 2011 case. The state made a deliberate decision not to disclose the identity of a CI to the defense, which led to the lengthening of the time before trial. And what they say is gamesmanship is more than negligence. Hayes v. State, 298 Georgia Appeals 338. The state decided to dead docket a case and then call it back up years later.
Is that the case? Is that the case in this particular circumstance?
Well,
it's different in this case because they have continually tried to investigate it. So let's move on to your assertion of the rights for your trial. I'll agree with you. Your client asserted his right to trial on at least 3 different occasions. Would you disagree with that?
And I would just ask that you would note that really the most important one is the first date, which was in 2019.
What date was that, sir? I have the 9 May 22 and the 5 August 22. What?
I'm sorry.
Go ahead. July what?
July 2nd, 2019.
Okay, so he's at least asserted 3 times.
Correct.
So the court will go ahead and do that. But let me ask you this question here. Okay, so the incident date occurred in 2015, October 27th, 2015. So he waited some 4 years or thereabouts, almost 4 years. I'm terrible at math, but almost 4 years to ask for that particular trial to be, or assertion of the right to trial. 3 years and some months.
Yeah, 3 years and some months. And it sounds like the state was making a point that he was in prison at that time. But, Your Honor, that case was unindicted. So he never had access to discovery. The case law says that failure to disclose discovering is a mitigating factor in a delay to assert your constitutional speedy trial rights. And I'm getting that from
Okay, when did they indict the case?
well after he asserted.
As it relates to Mr. Stillwell.
They never indicted the murder by itself. And that's the whole point. That it's a simple case that they made. Indicted this murder case.
When did your client file a statutory demand for a speedy trial, or did he ever file one?
He's never had an opportunity to
Did he ever file one? No,
there's no.
Okay. All right.
Your Honor,
I agree.
on New Year's Eve at 12:01 a.m., after I kiss my wife under the mistletoe, I will file a statutory speedy demand. But there's no point in filing a motion, a demand that has no legal basis. In fact, lawyers are told not to do so. It's clear that there is no legal basis to file a statutory speedy trial demand at this time. If you want me to file one, I will.
I just want to make sure we understand one. Okay, you're good. You're good. Okay, so all right, so
but we've had these constitutional speedy demands in.
All right, should I weigh that factor against the state or against your client?
Well, I think that it's neutral.
State's asking me to weigh it against you.
Well, of course they are.
Because you didn't ask for your client never didn't assert the right to a speedy trial.
They wanted him to assert when he was in prison back in 2016, 2017, when I wanted them to indict the case. So, yeah, of course they want that. But again, it would be error of the court, respectfully, to fail to consider the mitigating factors of the failure to disclose discovery. And that's State v. Buckner, 292 Georgia 390 at 397. That's 2013. And delay in indictment is a mitigating factor, and that's Hester v. State.
Okay.
And
what's the site on Hester?
I'm going to get it for you, Your Honor. I thought. Yeah.
Does Hester talk about why the delay in indictment?
I can answer that in a second. Oops. It was a vehicular homicide case. It was a 5-year delay. More than 5 years. The defendant did not assert until after 5 years. And it was error for the court. The holding of this case was the trial court erred in denying constitutional speedy and dismissing the case. And the trial court erred in failing to consider mitigating factors such as the delay in indictment. And also in that case, which admittedly does not apply here, the failure of the defendant to be appointed an attorney in a timely manner, which may apply to other people in this case, but
okay.
So that was the facts of Hester v. State, but I would also
well, State cites Henderson and they cite Johnson. Johnson is to invoke a right to speedy trial. The accused must assert it to the court, and then Henderson, that's it. Johnson's 291 Georgia, 863 pinpoint 866, and then Henderson is 310 Georgia, 231 pinpoint 237.
And in all respect to my colleagues at that table, I just and I'm not saying that this just came up today and they were working hard on it. They gave me their brief today, so I haven't really looked at those cases, but I will say in their brief, they're arguing that, again, an impossibility, and I can't even believe that they're making this argument that I have failed to file a statutory speedy trial demand, which I know we discussed, but, quite honestly, I think that
You can't file something that's not there, so
Well, that's in her brief, so
I know.
skeptical.
And I'll be interested to see what Mr. Anderson, is it Mr. Smith? I'm sorry.
Armstrong.
Mr. Armstrong. I knew it was something.
14 years the open call me.
Oh gosh, Mr. Armstrong. I'll be interested to see what Mr. Armstrong says about that. But we'll. All right. So tell me about your prejudice. That's the.
Well,
You argue oppressive pretrial incarceration and death of a witness. So, well, it's pretrial incarceration is presumed to be of harm to the defendant to begin with. So you can certainly.
I'm not going to focus on that, Your Honor.
Okay.
And so, but the point I would first make is actual prejudice, which I'm going to get to, that we do have in this case. But actual prejudice is not needed when the extraordinary length of delay raises a presumption of actual prejudice.
Okay, but I'm telling you,
after such a delay, the showing of actual prejudice is not needed, and that's Grizzard v. State, 301 Georgia Appeals 613, Redding v. State, 313 Georgia 730. That's a 2022 case. Hester v. State, which I've already cited. And the greater the pretrial delay simultaneously presumes and decreases the expectation that the defendant can demonstrate tangible prejudice to his or her ability to present a defense.
okay, but here's the thing. The first thing is the state has given you a reason as to why the case took so long. So address for me, and you keep going back to that issue, but I'm telling you, like you said, the factors are interrelated. I have to decide that to begin with. So address for me the, whether or not your client's been prejudiced.
Well, Miss Love, in her redirect, made my point.
Made you what?
Made my point.
Okay, all right.
They have this witness, Tremont Stillwell, who says that my client gave a third-party confession in the park in front of Vanetta Guffey. I think we would all agree that a third-party confession is pretty substantial, important evidence. I don't think anyone would disagree on that. If they disagree on that, they can, choose not to enter any third-party confessions. So, Mr. Sprinkle, in following up, doing what he's supposed to do to investigate, brings in Miss Guffey. Miss Guffey, Mr. Sprinkles testified to this on cross. She said two things. Mr. Stillwell, meaning Tremont Stillwell, her husband, I believe it's actually like a common law husband thing, is a liar. That's one thing she said. And two, she denied being present at any conversation, any confession, anything involving Shannon Stillwell. Okay? She pushes back and becomes a defense witness that would impeach Tremont Stillwell. I think that's pretty clear. Somehow, and now she's no longer with us, sadly, and she's not available as a witness. Somehow, the prosecutors in this case, they just showed their hand. Somehow, her saying, I don't know anything about it, it never happened, and storming out has become evidence that somehow she knew about this homicide and associates Shannon Stillwell with the homicide. And now we're speculating and inviting speculation from presumably the jurors at some point about all this stuff. And all I want to do, call Miss Guffey to the stand. All they want to do is twist everything that happened in that room into the worst light possible to aid in their case, which they delayed in bringing, and which Miss Guffey passed away tragically during their delay. And that is the exact problem. That's the exact problem. I want that live witness. Okay. And Your Honor, and I will say,
we don't know whether or not the state's going to call
Well, they
that
have.
took her Stillwell, and you know, whether or not that's going to be relevant at that point in time. They also going to have it in the correct form to even have it admitted. So it's really dependent upon a lot of things that may or may not occur in this particular case. So,
and Your Honor, I will also, I don't think Your Honor disputes that the unavailability is in dispute here. I think that's obvious. I think the prejudice is obvious. The degree of prejudice.
but the state didn't cause the unavailability. You'd agree with that, right?
I don't think they literally killed.
No, I
Miss
mean,
Duffy?
she
No.
died of natural, but she died of a natural cause. She had an aneurysm. Is that correct? Okay, all right. Can you answer one more thing going back to the prejudice? Was your client jailed for anything during that particular period of time on unrelated charges?
I cannot. I defer to Department of Correction records on that. Are you speaking to the 254 days that were discussed?
Well, I'm talking about the period of time, probably from 2016 to the time of the indictment. Was your client serving any other time in custody for any other offenses? I'm only asking for that because it makes a difference in the analysis.
I would defer to the Odyssey jail records on that. I think that there's likely periods of incarceration in all candor to the court. But Your Honor, I would like to also point out that that Hester case that I cited also makes it clear that the impact of a live witness testifying from the stand with the jury able to determine the witness's demeanor and credibility is what is important. And a transcript and a tape recording is not the same thing. We want to have the jurors be able to compare the demeanor and reliability and believability of Termon Stillwell versus Vanetta Guffey. And we have been denied that through this delay. You know, I know Your Honor's going to find out how Your Honor finds. But again, I gotta follow the factors, the four factors. And I understand, Your Honor, but I just would like to stress, while I'm not saying that they knew she was going to die, what I am saying is they could have brought a very simple murder case against Mr. Stillwell many years ago. And they made the deliberate decision, the deliberate tactical decision to put it on this indictment with all these other individuals, with all these other overt acts, and with distinct rules of evidence that apply. So they did get it. Isn't that their choice? I mean, they're the state. Isn't that their choice in terms of prosecution? It is their choice, but it doesn't make it right. It's not the way Max Sharp would have prosecuted this case. If you were the district attorney, you would have probably prosecuted just like that, right? I don't know what I would have done. That's why I'm not a DA, but and I never will be. But, all right. But Your Honor, I will say though that they triggered this with the arrest, and then they decided to make this one incident a very complex, a part of a very complex case, and that was their deliberate decision. And they knew that my client had not only a right to a speedy trial, but had asserted his right to a speedy trial when they made this decision. And that's the problem. Okay. Thank you, Your Honor. You're very welcome. All right, Mr. Armstrong, finally got your name right. Sorry, I apologize. Might just be back in contact over the past several years.
Absolutely, Your Honor.
It's been a long day, but go ahead, sir.
One thing I'm going to go in the order of the analysis, but one thing I wanted to begin with, because both the court and Mr. Shard assumed that I conceded a certain thing, but there's a nuance to it that I wanted to draw out for the court. Mr. Shard isn't simply attacking count 2. He's attacking count 2 and any count upon which is predicated on count 2. That's a coy way of referring to count 1.
Yes.
And so you have two different issues, and I submit to the court that those are two different speedy trial clocks, because the RICO conspiracy is the entire conspiracy, which extended into this year to include the murder of...
Count 2 is the dogged factor for four factors. What about count one?
Count one, we have not reached the threshold yet because the conspiracy bled into this year. And I've cited an Ohio case because there's no Georgia case that has decided the issue. But essentially, you go from the arrest or indictment for RICO, which happened this year, when you're dealing with the RICO conspiracy itself. And so because they're making claims against both count two and count one as something predicated on count two, those are going to be separate analyses for the length of time.
Is that State versus Messer 207 Ohio 5899? You cite that for that proposition?
Yes, Your Honor.
Okay.
And I would just like to be
Speedy trial timetable for the RICO charge begins to run upon the date of the defendant's arrest for the RICO charge itself, not upon the dates of arrest for the predicate acts.
That is correct, Your Honor.
Okay.
And I'd just like to be clear that I did not select like the best case for me. I looked for the entire nation, and it doesn't seem that I could find any other case, any other court that had addressed that issue. This is the one court that I had that had addressed that issue.
All right.
And so I wanted to make that distinction that even if the court were to find something as far as count two, it would not apply to count one, and the case would still proceed with the information in count two against Mr. Stillwell. The length of the delay, the court has indicated that the court was going to hold that benignly against the state. I've made my arguments in the brief, and so I'll move on from that. The cause of the delay, you heard Mr. Sprinkle, Deputy DA Sprinkle testify here today. And that was the reason that we brought in his testimony, because Mr. Sharp did not make a specific allegation that the state had intentionally acted to gain a tactical advantage and hamper the defense.
Do you want to break down the time periods so to account for them?
Yes, Your Honor.
I think you've got 27 October 15 to 13 November 2018. And then you've got another period of 13 November 18 to May 9, 22, and then May 9, 22 to present.
Correct. So I divided those times this way for this reason, because Mr. Sprinkle had the large 140-page summary of the investigation as far as the case was concerned. That's a very, very large summary. That's not a summary that I've seen before, that length of it. That's the complexity of just the murders, I understand it. And so I wanted to draw that period of time because we have not just the live testimony, but his adoption of the more details that are in there to show the scope and what was going on in the investigation shows the justifiableness of the investigation. From the period beyond that, we don't have a document to hand the court, but you heard Deputy DA Sprinkle testify about ongoing investigation, ongoing work with different prosecutors. And as the court noted, basically realizing that this was a large RICO conspiracy and trying to put all the pieces together and moving forward for that. I also want to mention that during that period of time was the COVID shutdown, which affected every part of the criminal justice system. And so I didn't want the court to, we have not been dealing with perfect normal times throughout this entire process. From May 9th, 2022 to the present, that was the date on which the original indictment came down, assuming that I have the correct date. From that point until now, everything has has moved forward appropriately. There's been no unjustifiable delay. It's basically been a regular case. You've gone from May 2022. We are now in December 2022. That's 7 months, and we're at the precipice of trial. That's a very, very quick turnaround. So I suggest to the court that that is an entirely appropriate delay that shouldn't be weighed against either party. But the main thrust of it, and I believe I heard you discussing with Mr. Sharp this, the state submits that it was a justifiable delay in dealing with the investigation for this case. The individual murder itself was complex to investigate, including original assertions that turned out to be false. And you have it being clear from the beginning that it was the precipitation for an ongoing set of violence between two rival gangs, and that ultimately became part of the RICO conspiracy. There is a case for the length of the delay that I'd cited that I think is also relevant for the cause of the delay, where I discussed there's a Georgia Court of Appeals case that had a 12-defendant RICO case that had a smaller number of predicates, where they said that that's the type of case that justifies a longer investigatory delay than a more simple event that doesn't have that conspiracy going on. Now, this will be. I did want to mention a few things about the third factor, which is the assertion of the right. I'm going to address an issue first that's a little bit more specific. I would normally begin more globally, but you were talking with Mr. Sharp about statutory speedy trial demands. That's not what I'm hanging my hat on. However, I interpret the rules, including Judge Brasher's statutorily approved pause of the statutory speedy trial demands, very differently than Mr. Sharp does. It is not something you can't file. It simply says the time the state has is paused until the January term of court for 2023. It doesn't say you can't file it. And I don't know who he's referring to who says you're not supposed to file it. I've not heard that. I'm not aware of anything of that. When I read the order, I fully expected the statutory speedy trial demands to keep on coming, just that they would not have their time towards the clock run as far as what the state has to do to meet them. And so Your Honor was interested in hearing what I had to say about those. That is one bit, because he couldn't file. Let me back up for a second. Mr. Sharp had made representations in the brief of what he could or could not do.
He could have filed it. It just wouldn't have been. It wouldn't have taken effect because the delay. I mean, the Judge Brasher's order and the Supreme Court of Georgia's order told those until January 1.
Correct.
So they would go live on January 2nd of the 2023.
Absolutely. And so the fact that he didn't file a statutory speedy trial demand is something that I just include based on the demands for trial that are made this year. One of the things that the court is going to be looking at is the vigor and the strength with which the assertion was made. And that leads me to the other issue, which is Mr. Sharp mentioned in both of his motions to dismiss the original one and the amended motion that he could not have filed a formal demand for constitutional speedy trial without an indictment. That is absolutely false. You can do that the first day of your arrest if you want to. And in this case, that actually happened. And I submit to the court that since he filed on December 13th the amended motion, and given how it reads, where it asserts that he can't make a formal demand for speedy trial, and where he does not mention the 2019 assertion, I assert that if the defense doesn't even know they've made an assertion, it's not a strong one. The 2019 motion, it was not mentioned in his filings. It was not mentioned in Ms. Rosenwasser's original response to the court. And I found it last night. I had 3 copies to bring it, but it seems that Mr. Sharp has found it in the past week to mention it. The document itself, I'd ask the court to look at the certificate of services off. It doesn't seem normal. And so we don't know exactly whether they filed it correct. What they did, because they just say this hypothetical other things. And so I just want to mention that, because no one in this case was aware of that demand for speedy trial until this week. There's no one who indicates that they were aware of this. Why wasn't this a part of the motion to dismiss that was made months ago if the defense was aware of it? So I just mentioned that because we are now aware that there was the demand for speedy trial. I don't know if anybody was aware previous to last night when I discovered it, as far as the state is concerned. And so I mentioned that for the strength and the vigor with which the assertion is made. Now, I do not contest that the court has to weigh in some way the period of time since the demand, because the demand was weighed. But the issue for the court is how to weigh it. And I submit that it was not done. It was a very, very weak assertion of the right. However, as the court identified in speaking with Mr. Sharp, the period of time leading up to that in which he absolutely could have filed a constitutional speedy trial demand is something that I think you should weigh against the defendant, because that is a number of years for which he would have been charged with murder, which goes to his ultimate claim about the length of time. Now, I would like to move on to the fourth prong, which is the one about prejudice. And the whole reason that you go into the Barker versus Wingo factors is to see if seeing those 4 factors as a whole outweigh the presumption of prejudice that occurs from the length of time that gets you to those factors in the first place. There's been no showing of any demonstrable harm, and I'll explain both of those things. I showed my work in writing the state's response that I was able to file today, and I would just like to confirm what Mr. Sharp said. He did not see the brief before today. I became involved yesterday when the trial team was unable to make the response in time for today's hearing. And so I showed my work in the procedural history of the case to describe all the periods of time in which the defendant has been in the Fulton County custody since his arrest on October 27th of 2015. That period of time that he was originally in the Fulton County Jail through that date to part of 2016, he was also in jail for other charges. And when he pled guilty to those other charges, as cited in the state's brief to both booking numbers and to other case numbers that are within the court's records on Odyssey, every day of that was attributed to something that he got credit for time served for on the 10-3 prison sentence that he received for that other case. He left Fulton County's custody to prison, served out his sentence, and at that point he returned to Fulton County and bonded out the next day. So that one day in October 2018, the full day, so it's from the 23rd to the 24th, so it might technically be 2 days, but it seems like just one full day. That's the only day that I can identify that the defendant was in the Fulton County Jail for no other reason than than the incident in which Donovan Thomas was murdered. There are intervening situations in which the defendant entered our prison under new charges and either resolved them or simply left the jail without them being resolved over that period of time that goes beyond that. And again, I've cited the Fulton County case numbers that apply to them as well as the jail booking records that this court has access to through Odyssey. On March 17th, 2022, the defendant entered the jail once again. That's what he's currently been in there for. And that was for the separate additional murder of Shimel Drinks. And since that point in time, he has been in custody that entire time to this day on those charges, as well as any other charges that he may have. The relevance for which I bring this up is that, number one, the court said that any pretrial incarceration is prejudicial under the prongs. That's not entirely accurate. It has to be oppressive pretrial incarceration. The courts have determined that simply being in jail does not set that apart from other circumstances. He has alleged issues about being stabbed in the jail this year, but there was no evidence that was presented to the court about that. I'm not personally well. ADA Sprinkle was not either. I'm not saying that it didn't happen. That's not something in the record currently before the court. What's important, however, is I've cited case courts, primarily the Georgia Supreme Court, which collects Salahuddin, Treadwell, Dagenbaugh, and I apologize to the court reporter for the spellings of every one of those names, as well as Cawthorn, where essentially, if you are in custody for something else, that cannot be oppressive pretrial incarceration for the purposes of Barker versus Wingo for this case. And other than that one day in October 2018, I'm not aware of any point in time in which Mr. Stidwell has been in the Fulton County Jail for no other reason than the murder of Donovan Thomas. And so I wanted to point that out for the court because he's not shown demonstrable prejudice in that regard. Now, the death of a witness is absolutely something that is a concern and something that comes up in constitutional speedy trial cases. However, in this particular case, the issue is it's essentially speculation as to what she would say otherwise. We have the fact that she said that her husband was a liar and that he was unreliable. We have that. It is literally recorded. And so, as the court noticed, we don't know at this point in time if the state's going to call that particular individual the relative of Mr. Stidwell. We don't know that we're actually going to call that specific individual when it comes time for trial. However, if we do, the defense has the statements in which she literally said those statements that they know of. They have a recording of that. And the state offers to stipulate that that will be admissible against, in Mr. Stidwell's case at least, for the purposes of dealing with the, I apologize, is it Jerron Stidwell? Tremaine Stidwell. I apologize. I got confused as to who was speaking with. It's Theron Stidwell.
Your Honor, just for the record, I think I need to say this. We do not feel that the offer of stipulation is sufficient. The reasons I stated.
Okay, that's fine.
And so getting in that information is something that they would be able to do. It was my understanding from reading their brief that they were saying that they couldn't call her to impeach the relative.
If he's called.
Pardon?
If he's called.
If he's called, correct. And so that's why I cited case law that indicated that the potential prejudice from the death of a witness is alleviated when the state offers to stipulate to the information that they would have been able to get in otherwise. Going beyond the recorded statement that she has would be speculations why she acted that way. One of the reasons that Ms. Love had the cross-examination or the redirect examination that she had showing this evidence that she might not be the best witness for Mr. Stillwell, because she might absolutely have been able to say that that did happen. She just didn't want to talk to the police about that. So one way or the other, it's speculating as to what she would say on the stand. What we do have is the statements in which she called her husband a liar, and those are recorded. And if I believe that they are been turned over in discovery, that is my understanding of it. And so that is something that exists in this case. The state submits that the court should, in weighing these factors, the appropriate outcome would be that this is not an issue in which his constitutional speedy trial rights have been violated in such a way that the court should grant a motion to dismiss. And the state is asking the court to deny the motion.
Thank you, sir.
Your Honor, may I respond just brief, very brief?
Your viewpoint of brief is worrisome to me.
I mean it this time. I swear. Judge, two things. Again, we're speculating. That's my whole point. Speculation is bad. Live testimony, good. That's what the jury needs. That's what we're deprived of. Also, our assertion of constitutional speedy, Mr. Armstrong is calling it weak. I have never seen in any case law in my life some differentiation between a weak and a strong assertion. It's a piece of paper that says a very standard thing, which is we are asserting our constitutional right to a speedy trial. It's fairly boilerplate, and it was entered into Odyssey in this case, so I don't know of any service errors. It is true that things are more difficult for the defense to find because of our lack of access to Odyssey, which is a very uneven playing field, which I will be bringing a motion about later on. But that's just what I wanted to say. Thank you, Judge.
All right, you're very welcome.
Wait, I had something.
Uh-oh.
John, if you would just please take an additional notice, the state brought it up, we didn't introduce anything about this. That we're having problems at the jail, and the court's well aware that he is in protective custody and isolation. Therefore, that would be the reason for the question.
Okay, all right. Okay, let me go ahead and just indicate that the state of Georgia filed a response to in opposition to the defendant's motion to dismiss. And Mr. Armstrong, in his procedural notes, I'm gonna mark that, Christine, as the next court exhibit in order. It'll be just for the simple fact that it'll give some indication about what I considered. It has a really good procedural history of the case, which I will adopt in my order, giving the full of how we got from the arrest of Mr. Stillwell on or about the 27th of October of 2015 to our current posture in this particular case. So I will, without me kind of dropping it out on the record again. The next thing I will indicate is, of course, the constitutional framework for considering a speedy trial demand. It's found in the seminal cases of Barker versus Wingo, 407 U.S. 514, 1972, and Doggett, DOGGETT versus United States, 505 U.S. 647, 1992. Those particular four-factor balancing tests The first part requires the court to determine if the time between the defendant's arrest or indictment and his trial was long enough to be considered to be presumptively prejudicial to the defendant. If presumptive prejudice threshold was crossed, the court proceeds to the second part of the framework, applying the content-focused four-factor balancing test to determine whether the defendant was denied the right to a speedy trial. Those factors the court must examine are 1, the length of the delay, 2, the reasons for it, 3, the defendant's assertion of his right to speedy trial, and 4, prejudice to the defendant. And I'm required to look at those factors and the fact there are a number of cases that include Heard versus State 295 Georgia 559 pinpoint 562 to 563. It's just one of many cases that tells me what I'm supposed to apply that framework. Of course, as mentioned earlier, as to count 2, the defendant was arrested more than a year ago, so I'll apply the Barker-Doggett factors to that count. As to count 1, that count is, I agree with Mr. Anderson that we haven't addressed that particular issue, and that the same speedy trial demand or the time does not apply to predicate offenses in the RICO charge at this point in time. And Mr. Anderson cites State versus Messer 207 Ohio 5899 P18 Ohio Court of Appeals 2007. So the speedy trial timetable in regards to the RICO charge begins to run upon the date of the defendant's arrest for the RICO charge itself, not upon the dates of the arrest for the predicate acts upon which the RICO charge was based. So in terms of count 1, it fails. So I agree with the state on that particular issue. Now, as mentioned earlier, this case took a little bit of time to get acts. A homicide, a purported homicide is cites Schuyler as SECHLER versus the State 316 Georgia Appeals 675 2012 case for the proposition that Mr. Anderson cited for that case involved 12 defendants, continuing enterprise, 20 predicate acts, and it justifies the length of the time. In this particular case, we have much more defendants as well as predicate acts, and it took a little bit of time for this to get together. So in terms of the state's ability to prosecute the case, so much longer length of time justification in this case due to the complexity and the work. I'm going to weigh that against the state benignly. As for the second factor, cause of the delay, there was no deliberate attempt to delay the trial in order to hamper the defense. It just took a little bit of time because this was a very unusually complex case. And in terms of the division of from October the 27th, 2015 through the present time, the court will adopt Mr. Anderson's review of the particularized investigation and the reasons for the delay. And I'm not going to weigh this time against either party. Now, as for the assertion of his right, Mr. Shart does reference that he could not have filed a statutory demand during that particular point in time. And and that the constitutional speedy doesn't apply. I agree with Mr. Anderson. In fact, a constitutional speedy trial demand, you can apply ones from the time of arrest. You can, if you want, you choose to do so. Also, taking judicial notice of the order from the Supreme Court of Georgia, as well as from the Honorable Christopher S. Brasher, former Chief Judge of our court, that you, Mr. Shart, you could have asserted a right. The question is whether or not it would have, those two orders from the Supreme Court as well as from our court basically told those particular speedy trial demands, those people who filed them during this particular period of time, and would have made them come alive again on the 2nd of January of 2023. So I do have to weigh that against your client, since he did not assert his right up until the time periods that you indicated earlier to the court, those being July the 2nd of 19, May 9th of 22, and 5 August of 22. In terms of whether or not the defendant's been prejudiced, the defendant alleges two bases for prejudice. One is oppressive pretrial incarceration, and the second one being harm to his defense due to the death of a witness, that being Vanetta Guffey. In terms of pretrial incarceration, Mr. Stillwell is not served a day of incarceration based solely on the murder of Donovan Thomas. He's been, and outside that one day, I agree with the state that he's been incarcerated for other offenses on top of the alleged murder of Donovan Thomas. And I'm going to reject his claim that he suffered oppressive pretrial incarceration from this prosecution. In terms of the death of the witness, Miss Vanetta Guffey, the state is in concurrent. I mean, the court is in concurrence with the state in terms of the speculative nature at this point in time of the calling of Miss Guffey to refute anything from what is Mr. Stillwell, not the defense, Shannon Stillwell, but Theron. Thank you very much. Theron Stillwell, if you recall, to testify, and the state has offered in this particular matter to stipulate to that particular test. And even though that particular issue, should there be a need to do so, and I know, Mr. Shart, you have mentioned that, of course, live witness would be a better witness, but unfortunately, she has been called home, and that's not going to be a possibility in this particular situation. But right now, it's speculative in nature. So, for the above aforementioned reasons, I'm going to deny the defendant Shannon Stillwell's amended motion to dismiss and amended motion to dismiss the indictment on constitutional speedy trial grounds. Mr. Anderson, if you would prepare a suitable order memorializing the court's resuscitation, send that to Mr. Shart for his review and comment. And if you could get it filed sometime in a most expeditious manner, that would be greatly appreciated.
Yes, Your Honor.
Okay.
Call Mr. Stillwell. And just for the record, I haven't seen
Theron Stillwell. Termon Stillwell. Okay.
And Your Honor, the state should elect to call him, they will revisit this issue because it will no longer be speculative.
Well, it would be an evidentiary issue at that point in time. So, of course, it would be subject to a proper evidence objection at that point. Okay? All right. Folks, we've kind of come to the end of the day. Let me go ahead and just review Ms. Rosenwasser and for all of the lawyers in this particular case. I know we were supposed to call Mr. Hall today. We're not going to get to him given the hour of being 5 of 5 on today. So if we could potentially have him as one of the individuals we could call. I was going to ask Ms. Rosenwasser, is it possible for you to basically, for maybe us to move through the 5 witnesses that you have in terms of length and then call Mr. Hall, and then we could kind of bleed him over into the 22nd if necessary?
I'm not sure it's very long. I believe he's still waiting for us today, so I believe his hours are usually 7 to 3, so he had been planning to ask if he could probably start it off, so I'm not sure if he's available on
Now, tomorrow.
but please.
Well, why don't you ask him? I mean, look, he's a witness that's I'm sure is familiar with this kind of. I mean, our issues involving calling witnesses.
He's advised that we could put him on call for tomorrow afternoon.
That would be great if he could potentially be ready to be on call between 12 and 1. Would that work? Appreciate it. Thank you, Officer Hall. I really appreciate that. We just had a long day, okay? All right. Thank you, sir.
Your Honor, there's 4 others, and the other person who's listed yesterday, listed for tomorrow, we actually called her yesterday.
You have John Paulsnick.
Yes.
You have Dr. Henninger. Oral.
Yes, we can get them all.
Okay, if you'll call them before we deal with Officer Quentin Hall, that would be great.
We can do that, Your Honor.
Okay, all right. Well, that's our order of march for tomorrow. Any other administrative announcements you need to make on behalf of the state?
I believe so, Your Honor.
Okay, all right. Defendants, any defense attorneys, anybody? All right, we'll see you all in the morning, 9 o'clock for an anticipated 9:30 start time.
Everybody